Kirk Glasso versus Artie Dracos.
Good afternoon, Your Honor. Jay McCurgy appearing on behalf of the plaintiff.
Oh, this is Gata. Dari.
Your name again, ma'am?
Gata Dari.
Yes, and for whatever reason, I skipped your name, but you're also on this case. All right, folks. This is the second hearing. Did we get the money judgment corrected?
I believe so, Your Honor.
And again, counsel, I apologize for that. It made no sense to me, but yes, we do. We're good. Okay. So where are we now in this case?
Your Honor, last time we met, Miss Dari was stating her case as to why she didn't believe she should be on this money judgment. I'm here with Mr. Glassel, and we have reasons as to why we should. If the other parties are not available, we ask for a
Can take a default as to them. Ma'am,
Yes, sir.
you
Yes,
never moved in. Is that correct?
Correct. So due to personal reasons, I did not move in, family health issues. So I reviewed the document or the rental agreement. It says the lease agreement did not stipulate any notice requirement. And so if I had the intent of vacating, or as far as I know, again, a layperson, I can go as far as what I read. So when I made the decision not to move in, that was due to a personal reason. So I never actually, within 2 weeks of actually signing the lease agreement, I decided to make that decision.
Ma'am, but you signed the rental agreement, correct?
Correct. With the intention of moving in.
Understood.
Mm-hmm.
The very fact that you didn't move in, you're still liable under the agreement.
You're right. As far as I understood regarding what was served to me, it was regarding a holdover, which I wasn't aware of any holdover, what was going on with them. I had to reach out to the real estate agent that found the location for me to understand what was actually going on.
Right, that's right.
And that was
a holdover. Yeah. So, counsel, is all of the rent owing after the lease? After the lease had expired?
Correct, Your Honor. The lease. Oh
no, the last time they made a payment was February, I believe.
February, Your Honor, was the last payment we have.
And then the lease, I think, expired March 31st. So I'll talk to Sophia. She informed me that everything was up to date in regards to the actual rent. So it was 1 month.
Your Honor, if I may clarify, or if I may add some light as to our position, it would be the parties were both represented by a realtor. Miss Dari and Mr. and Mrs. Dracos applied together. If my client had thought Miss Dari was not going to move in and be a guarantor, we would have signed a guarantor agreement. It was Miss Dari's income that was used to approve the lease or approve the ability to move in. We were never notified that she wasn't in the location. We were never notified that she moved out, which I guess she says she didn't move in. She corresponded with the landlord as if she was a tenant.
I was coordinating because there was communicate.
Hold on a second. But counsel, does the leasing provision doesn't require her to say anything prior to the termination of that lease?
Require her to say anything as far as her moving in, or
well, meaning let's assume that all of the parties just vacated at the end of the lease, March 31st, they just leave. Your client wouldn't have claim for any rent thereafter because they wouldn't be holding over. The lease terminates of its own accord.
Correct, Your Honor. Yeah, I understand.
All right. So with Ms. Dari, why doesn't her interest just terminate?
So, our position would be that the lease holds everyone jointly and severally liable, and the lease also addresses the holdover period.
Right, but if there are three tenants and one moves out, they're gone. There's no lease. They just leave. You're saying she's liable for the other two staying?
Jointly and severally, we believe so.
Oh, I understand what the lease says,
Yeah.
but she's gone.
So, Your Honor, what we're trying to prevent, or what this could also be, is, and we don't know because parties were represented by a realtor, and my client never met these parties because of the realtor involvement. But we would not. What would happen if she applied just to approve them to move in and then never moved in? What if she was a straw person using credit or income to prove their viability as tenants and then didn't move in?
Okay, what if she did?
That's why we are trying. If we had known that, we would have used a guarantor agreement rather than having her listed on.
I get that, counsel, that things might have been done differently. But the status once she signed is that of a tenant. Whether she moves in or not, let's say she had moved in for a month and then she said, I gotta go for whatever her reasons are, I gotta go. But the tenancy is still paid for through the end of the lease. But she's not there. She basically has vacated. She's terminated her interest March 31st. Why is she liable for anything in terms of residency afterwards?
We have her listed on the lease as a resident and we're not notified or we did not know she moved out. I mean, she never said I never moved in. You would assume that she would have mentioned I didn't move in at some point, but during the entire tenancy, she was corresponding in the group chat as if she were one of the tenants.
Okay, but now she's gone. Let's assume that she was there even, okay? I know she's not. Let's assume that she was there. Come March 31st, she packs her stuff up, she vacates. Why is she liable for any additional rent? She's turned over possession.
Turned over possession to the other two tenants or to us? Possession was never
she is surrendered because she's left.
She never notified us of a mailing address, or how is the landlord supposed to know that
is she required to do that?
Michigan leases require notification of a forwarding address for purposes of the security.
If there's going to be an issue regarding security deposit, certainly.
Yeah, correct.
That doesn't trigger the forwarding address doesn't trigger anything.
So, Your Honor, the holdover provision of the lease would address holding over, and the jointly and severally liable portion of the lease would also state that the parties were jointly and severally liable for that holdover period. It would continue.
Your Honor, may I make a statement? Again, this is not my forte, as green as possible. This is just me doing my research. So I pulled up, and you can correct me if I'm wrong because I don't know this. It says Michigan law on joint and several liability. Under Michigan law, joint and several liability does not extend beyond the period for which I was contractually obligated. Any actions taken by the other tenants after the lease term ended could not be legally attributed to me. The Dracos family have solely decided without my knowledge or consent and continue to live there past the contracted date. Michigan law supports that the tenant cannot be held liable for actions of other tenants once the lease obligations have been fulfilled.
I don't know what you're reading from, but I don't know what you're reading from, but that's fine. That is indeed my understanding.
That's what I pulled from. Yeah. So again, I don't know. I'm representing myself as very minimal knowledge.
No, I understand. I'm just saying she contracts for a year. She fulfills, however that happened, doesn't really matter. She fulfills that her obligations for that year. Contract ends. She's not in the premises, which was what the subject matter of the contract is. There are people that may be in the premises. That's fine. But I don't know how her obligation continues.
If her obligation were to end, Your Honor, she would then still be liable for March rent. So we would ask for the judgment for
March rent may be an issue if it goes through March. If March wasn't paid, certainly.
So for
I don't think in anything, and Ms. Dyer, you can correct me if I'm wrong. I don't think in anything she has said, doesn't hold some liability for the lease term. And she believed that it was all paid through the lease term, but if it's not, she's liable for that. I don't have a problem with that. It's the period in time after the lease ends, because at that point, she's no longer occupying the premises. She never did, but certainly after the lease term, she's no longer occupying the premises.
Respectfully, Your Honor, may I ask, what was the total amount? And I can pull up the contract of, because again, I was informed by Sophia that they're up to date on everything. The actual lease agreement and I can pull it up right now. She's a realtor she noted, like when I got served, I communicated with her. I'm like, hey, what's going on? Yeah. So there was what is the deposit? How much was the deposit total?
the security deposit?
Security deposit, which I'm sure it wasn't sent back to them. There's still a hold.
Yep, we have 5,700.
And how much was rent total?
3,800.
3,800. So
hold on a second. Stop.
Okay.
Just stop for a minute. Counsel, you're telling me that there's a $5,700 security deposit, right? There's 3,800 owing in rent.
No, there's the monthly rental payment was 3,800. We have rent owing at
1 month.
No,
so folks,
there's two different.
We have an alarm going off, so I'm gonna have to stop this proceeding. I'll come back at some point. I'm sure you can hear it probably. Court stands in recess.
District Court, Washtenaw County, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge Kitson presiding.
And good morning. Court does call the case of Jacob Properties Management versus Justin Reeves.
Justin Reeves here. Good morning, Justin Reeves here.
I got you, Mr. Reeves. We got the attorney. Counsel, state your appearance.
Jay Mukherjee appearing on behalf of the plaintiff.
All right, thank you. What's the plaintiff's claim in this case?
Your Honor, we have rent in arrears for 1,700, late fees of 1,300.
13.
Correct, Your Honor.
So I have rental arrearage of 1,700, late fees of 1,300.
That's what we have, Your Honor.
Okay, before I say anything to Mr. Reeves, where's the 1,300 coming from?
$50 late fee, 26 days.
Pardon?
$50 late fee for 26 days.
It's $50 a day?
That's what the contract states.
Yeah, that's illegal.
Oh.
Just on first blush. Well, let's just deal with the rent. How about that? Mr. Reeves?
Yes, sir.
How are you intending on paying the rent? I'm talking about the 1,700. I'll deal with the late fees in a minute.
I am saving my money, and I have reached out to Hawk and did a SER application. But I
You did
am
an SER?
working.
When did you do an SER?
Maybe 3 or 4 days ago.
Okay. All right. So you're entitled to a stay because of that, but you got to get the paperwork into us. Can you see your screen?
Can I see what screen?
Well, the screen that you're on right now, you're on a phone, right?
Correct.
Okay. If you keep swiping across, you're going to come across a QR code. That will take you to a form that you need to fill out and get to the court before Wednesday morning.
The one that says submit to 14A1.
Yeah, it's a form for rental assistance. I've got to have that form. I'm going to grant you the stay at this point because you filed for an SER.
Thank you.
Okay.
Yes, sir.
In the interim, is there any funds that you can pay?
Yeah, I can give them at least 500 today.
500?
Yes,
Okay,
sir.
why don't you do this? Pay 500 to the landlord today. All right. Get that
Okay.
form into us. Try to do that right away, okay?
Yes, sir.
Now, thank you for this being my first case, and let's have to deal with these late fees. But those late fees, counsel, here's what I'm going to do. You need to take a look at the case law. If the contract calls for a $50 late fee without getting into the weeds on it all and the details, a late fee can't be a penalty. That sounds to me on first blush as though it's a penalty. Also, late fees have to be related to the cost of collection, and can't be liquidated damages. So I'll leave that there and let you look at it yourself, or
Thank you, Your Honor.
or I'll do it for you at some point. So
We will strike those late fees, Your Honor. I did just see what you were talking about, so we'll adjust
Yeah.
that out.
all right.
And Mr. Reeves,
So I'm sorry.
if Mr. Reeves contacts my office, we can I haven't heard from him, so we can just
So
move forward.
we'll adjourn this out. He's going to get 500 into the landlord today toward the 1,700. How much is your monthly rent, Mr. Reeves?
1,700.
17.
Yes, sir.
All right. So the problem's going to be that as of tomorrow, we're going to click in another 1,700. So we got to try to figure this out. All right.
Yes, sir.
Okay. So I will adjourn this matter. We don't have next week. Well, he gets 2 weeks out. So
June 14th.
I'll adjourn this to June 14th, 2024, 1 p.m.
Thank you.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you. Court calls case Victor, is it Lacka versus Michael Conlon.
Michael Conlon here, sir.
Good morning, Your Honor. Kristen Davis appearing on behalf of plaintiff.
Okay, this is a termination case.
That's correct.
All right. And Mr. Conlon, what do you have to say about this case?
Well, sir, did you receive the 2 documents I sent to the court on Tuesday?
I have a document in big letters requesting a jury trial.
Yes.
And then a first request for adjournment.
Yes, those are the documents.
Okay. And so, counsel, have you received these?
No, I have not, Your Honor.
Okay. Mr. Conlon, did you send these to counsel?
No, I'm not an attorney. I did not realize I had to do that. So I just sent them
Okay.
to, yeah.
So that you know, anything you send to the court, you have to send to the other side so that everybody can see what's being sent.
Yes, sir. I'll keep that in mind. I hope to retain an attorney, so they'll know that.
All right, so you're looking to get an attorney on this case?
Yes, sir.
All right, so what I will do is I'll adjourn this matter out. My next date, council, is the 14th. So I'll adjourn it out to June 14th, 2024 at 1 p.m. Okay? And then we'll proceed from there. But sir, you got to make sure to get this over to the plaintiff's attorney.
Okay, I'll do that. Thank you.
All right. Okay, thank you, folks.
Thank you.
Court calls the case of Torrey LLC versus Ashley Sawyer.
Good morning, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
Ashley Sawyer. Don't have them checked in. You paid the second mailing.
I did, Your
Would you
Honor.
like to proceed with the default?
I would, Your Honor. I move for a default.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, sir.
Your Honor, we're asking for a possession judgment only. By default, we show rent and arrears in the amount of $1,450, costs including statutory attorney fees of $175, for a total possession judgment in the amount of $1,625, with the writ to issue after June 10th if that amount remains unpaid.
Judgment to the plaintiff. That is by default. For possession,
I will-
redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you. I will
All right.
submit. Thank you.
Thank you. Court does call the case of Group 5 Management versus Olivia Bell.
Good morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
Good morning.
And Ms. Bell,
Yes, Olivia Bell.
hello. Okay. How much is plaintiff claiming is owing? Claims is owing.
As of today's date, including the court costs, Your Honor, $959.
And ma'am, what do you have to say about that?
I want to know what the 900 and whatever he said is for.
$227 is court costs and the late fee of $75, and the balance is rent.
Rent.
Rent, $154.
I do not owe any rent. None.
Well, we're showing a balance owing of $41 from January and $154 from February, March, April, and May.
Your Honor, February
Yes, ma'am.
of this year, I gave them $2,100. I was cleared of all of that. Where this money is coming from?
Hold it, Ms. Bell. Hold on. When did you say you gave them the 2,100?
February of this year.
Okay,
I have-
Mr. Weiss, hold on. Hold on, Ms. Bell,
Yes,
hold on, just hold on. Mr. Weiss, do you see the $2,100 payment?
Well, Your Honor, we had switched operating systems, so the ledger I have does not show $2,100. I can go back with my client and get a ledger from the old system and see if it's there.
mhm.
All right, Ms. Bell,
Yes,
what's
sir.
your monthly rent?
154 now. It went all the way back down because they
Okay.
were charging me 297.
Okay, but you're at 154 now?
Which is
Yes,
what
sir.
we're showing, Your Honor, from February, March, April, and May, $154 owing, plus a balance from January of $41.
Right. But she's saying that 2,100 was given, so we gotta figure that out.
Okay.
So, Ms. Bell, So we're gonna click into June. When can you get the 154 in? Because I'm gonna adjourn it out for them to take a look to figure out where this other money is.
I just paid my 154 day before yesterday.
Say that again to me.
I just paid 154. No, I paid 159 just day before yesterday.
We're not
And
sure.
that was for your June rent?
My June rent.
Okay, so you paid that, you said day before yesterday, so you paid that on the 29th?
Yes, sir.
All right, let me just note that in the file. Arbor Woods versus Regina Johnson Agnew.
Sydney Fontanella for the plaintiff again, Your Honor.
All right, she here? Oh, there she is, trying to talk to me, but you gotta unmute.
Okay. Hello. Good afternoon.
Okay.
Sorry about that.
No, it's okay. You would look like you were saying something brilliant, but I couldn't hear it.
I was saying hello, Your Honor.
Oh, okay, well, that's brilliant. Hello, how are you?
I'm
All
well,
right,
thanks.
let's, okay. My notes. Well, you were hospitalized. Was that the last one?
Correct. Yes.
Yeah, that's what I
Okay.
thought. I hope you're doing well. And then you,
I am. Thank you.
all right, good. And then there was something with the union that was going to happen.
Yep. UAW Legal Services. They put me with an attorney out of Livonia, and I spoke with, I believe, Sydney. Is that you I spoke with yesterday?
Yes, Your Honor, if I may
Oh.
go ahead and kind of let you know what me and Miss Johnson Agnew spoke about yesterday.
Okay.
So Miss Agnew has been off of work. She plans to go back to work, I believe, on June 13th. She had given me a proposed payment arrangement. I had forwarded that over to my client. Unfortunately, I've not heard back about that at this time. And so we're kind of at a standstill right now.
Okay. All right. So here's what I'm going to do. Seems to be working potentially towards something.
Yes.
Let me adjourn it out a week then. See if we can get a response back and see where we go. And so it'll be May 31st, 2024 at 1 p.m. And let's see where we are, what we could do before we may click into June. But if we click into June, then we got to figure something out. Okay?
Okay. Thank you, Your Honor. And Sydney.
You're welcome. Take care.
Likewise.
Arbor Woods versus Dara Armstrong.
Sydney Fontanella for the plaintiff.
They're not here.
Correct.
They have not checked in. If you'd like to be sworn, you may take a default.
Your Honor, I'm actually not going to request a default. I'm going to ask for an adjournment for 3 weeks because there are some underlying issues that Ms. Dornbush has been handling, and I don't want to
Got it.
cause any other issues with that.
Okay. So how many weeks out?
3 weeks, please.
3 weeks. So the 14th. So I'll adjourn the matter to June 14th, 2024.
2 p.m.
2 p.m.
Thank you, Your Honor.
Thank you.
Have a good weekend.
I know. Okay. Is that it for Ms. Lupton?
Yeah. That's it.
That was it?
Yeah.
Wow. That's the first
I
time
know.
that's ever happened. All right.
First
have a great
time.
weekend.
Probably first and last, right?
Yes, exactly.
All right. Thank you. Take care.
All righty. Kirk Gassel versus Dracos.
Jay McCurgy on behalf of the plaintiff.
Got it done.
All right. Okay. I'm trying to remember exactly where we were, but I think it was really the March rent, which was the issue.
And then I'd asked how much the security deposit was, and I think he had stated it was like 5,600, and then the actual rent is 30. I don't even recall the actual total amount.
Right. The rent is 38, but that's only for 1 month.
And that was only
so well, but hold on. Even if I think you said the security deposit was 57, right?
Correct, Your Honor. Yes.
All right. So they could take the security as that, but that's going to happen at a different point in time. Have the folks vacated the premises to your knowledge, Mr. Kirji?
Yes, Your Honor, they have.
So does your client have possession back?
He does.
Okay.
Your Honor,
So he would, yes.
the lease states that the security deposit doesn't have to be used for rent and arrears, and he was planning on using the security deposit for the damages, which are extensive.
Where in the lease does it say that?
Page one, where it is.
Just one moment, Your Honor. Page 1, the security deposit.
I say in no cases is there obligated. You know what? I'm gonna tell you what. And I'm just gonna be blunt about it, but I mean, I'll listen to everybody, but it seems to me that this individual, Ms. Dari, that all she wants to do is resolve the account. It's a 1 month. And quite frankly, I don't think she's gonna be obligated for anything after that 1 month. And part of, if nothing else, if I were to take the security deposit divided by 3, about $1,900 you have of her funds that could be applied to whatever her rental obligation would be, remaining on that lease. The landlord doesn't want to do that. That's fine. I think the best thing to do is, since I don't have to grant a judgment for possession, I might as well set this for a final settlement conference and a trial. Because I think, and I'll be blunt, I mean, I think she's sitting here and that the position of the landlord regarding this tenant is whatever it is. I mean, I just don't think it's, I mean, she's not hiding from anything. She seems to be willing to try to resolve it. And I'm not sure that the landlord's feeling that way.
Your Honor, my client.
So I'll resolve it.
If we were willing to take, we may be willing to take the 1 month's rent, but there are other associated fees like an overdue water bill and some HOA fines that did occur before the 31st of March that we would like added to it, but we'll take the 1 month's rent as the court sees for this, against
Just the other stuff.
So we have overdue water, January through March, $610. We have late fees of $300 and HOA fines.
Late fees of $300 for how much? How many months?
It's 6 times. So, and 2 have been paid, so 4 times. The late fee is $150.
Okay.
I was unaware, Judge. I was unaware of any of this.
Hold on, ma'am. I hear you. I'll hear you, but so there's an additional what? 1,200?
So we have 610 in 600, and then we have a that's correct, 1,200. 525 in HOA fines. So
5 and
25 in the HOA fines.
What were those fines for?
There were about 24 HOA violations, I believe it was 24. Various things from leaving the dog leash and the cigarette containers out, trash in the lawn, not cutting the grass, leaving trash bins outside of the garage.
Tell you what,
an assortment.
You guys know how to get in touch with each other. I'm just going to set this for trial. Everybody come with what they have, and then I'm just going to make a call on it. I mean, like I said, I'll just be blunt. Miss Dari is here. If you're going to nickel and dime her, we'll just do it in a trial. And then I can make the decision.
Your Honor, we're not nickel and diming anyone. We're trying to uphold the.
I think you are. I'll be honest with you, counsel. I think when you start talking about HOA, why weren't they collected during the term of the lease from the tenants? Why wasn't there a filing before now?
So, Your Honor, the filing came, there was a negotiation for them to leave. There was an agreement that they would be leaving month, and then they asked for another month. And then finally, when we said we were filing, they vacated the property. So this was an extended period of time where we were expecting the property back.
Okay, but when you weren't, were you dealing with Miss Dari?
I included her on all of the emails.
Which
Who
I
were you
have.
dealing with? But who were you dealing with?
Well,
So, Your Honor, even the tenants themselves most of the responses were from their son, Nick Dracos, who may or may not have been living at the property. I'm not sure.
Non-jury trial, June 18th, 2024, 9 a.m. in person. Bring all your exhibits, bring all your documents, and then I'll just make a call on this. Miss Dari, you wanted to say something. I'm sorry, ma'am.
No, Your Honor, I don't have anything to really bring other than I'm the one that showed up despite I haven't lived there. The other tenants.
I know, and I just need you to show up at the trial.
Okay.
And then I'll
Okay.
deal with it from there.
And
Okay.
Your Honor, may we submit a default judgment for the other two tenants?
I'm setting the whole thing for trial. I'm not parsing them out. You won't parse them out. I'm not going to parse them out. Everybody be here on the 18th in person.
June 18th. What time?
18th, June 18th. I'll be in courtroom A. I'll have bells on. Everybody else have theirs.
What time, sir?
9 a.m.
Okay.
Court calls the case of Spice Tree Apartments versus Lauren Eccles.
Good afternoon, Your Honor. Rachel Dornbush, Pellets Law, on behalf of the plaintiff. And Your Honor, we are dismissing this case without prejudice as Ms. Eccles paid the remaining balance today.
Wow, that was easier than that last one. Okay, case dismissed. Thank you.
Your Honor, Ms. Eccles was signed in. She may have. Oh,
Nope, she's
still here.
there.
Yep,
Ms.
I wasn't sure if
Eccles?
she wanted to say anything.
No, thank you.
You okay with the dismissal?
Absolutely.
She decided she'd go outside in that sunshine that none of us are in. Okay, Ms. Eccles, you have a great weekend. Court calls the case of Arbor Woods versus Sarah Gillespie.
Rachel Dornbush, Pellets Law, on behalf of the plaintiff, Your Honor.
Hello, Your
Ms.
Honor.
Gillespie?
Yep, I'm here. I cannot figure out
Okay.
how to make my phone go on speaker, so I can't look at the camera and speak at the same time.
Okay. We'll work with it. We know you're there. Okay.
Thank you.
She paid the 1,500.
She did, and so the total, Your Honor, with costs is $460.71.
460.71. What's her monthly rent?
It is $13.49 plus a $25 pet fee, and then water sewer is metered based on usage. So $13.49 plus 25, $13.74, Judge, plus the metered water sewer charges.
Okay, so tomorrow we're going to be looking at being around the $1,700 figure. Okay, Ms. Gillespie?
Yes, Your Honor.
I'm taking, you don't have the 461 or 462 today. Is that correct?
I do, Your Honor. Actually, I can make a payment. Now what I need to know is if I have to do it in a money order like I just did, or am I going to be able to do that on the Arbor Woods payment site?
So hold on. So you can get everything paid today?
Everything but next month's rent. I just have to wait for
No,
my
it's
first
okay.
paycheck.
I'm not in next month. But
Okay.
if you can get the balance paid off today, that will be great because then the case can be dismissed.
Yep, I can have it paid today.
All right. So here's what I'm going to do. I'm going to indicate defendant's going to pay the balance today. My next date is the 14th. The fact she paid the 1,500, I'm going to trust her over plaintiff's objection. I'm going to adjourn it out to the 14th. Let her get this paid. If she doesn't have it paid, then I'm going to be dealing with June anyway. So.
Perfect.
Okay, Ms. Gillespie, you go over and get that paid.
Okay, they'll have it today.
All right, I'll adjourn it June 14th, 2024 at 2 p.m.
Thank you, Your
And
Honor.
hopefully we can have it dismissed. Okay, Mr. Leslie, you have a great weekend.
You too. Bye-bye.